There's one case that's been decided called IMS v. Sorrell, decided by the Supreme Court in June. And I think that's the most significant First Amendment case involving pharmaceutical marketing since the Washington Legal Foundation cases in the mid-1990s. In the Sorrell case, which involved data mining rather than promotional claims, the court said a lot of very good things about pharmaceutical marketing and applied a new standard for First Amendment review called heightened scrutiny. It's a much tougher standard for the government to meet when it tries to regulate speech. And while it wasn't directly on point to promotional claims, it's highly applicable. The second case is a case called Caronia. It's the prosecution of a sales rep for a company for making off-label statements about a drug several weeks before FDA approved the same kinds of statements in a supplemental application that the sales rep was making. That case directly deals with pharmaceutical promotional claims, and the court has asked for a briefing on how Sorrell applies to pharmaceutical promotional claims. And if the court applies Sorrell to promotional claims, we could have a whole new constitutional standard for review that has the potential for upending the entire promotional regulatory scheme. There are a number of different ways they could come out, but one quite plausible way is to simply say that truthful, non-misleading scientific speech cannot be prohibited by the government, even if it is off-label. Now, there's some caveats in there. The speech has to be truthful, probably has to be, although it's unclear, but it probably has to be scientific rather than advertising or something of that nature. And I could see them differentiating between direct-to-consumer promotion and professional promotion, but at least with respect to professional promotion, they could easily come out and say that truthful, non-misleading speech is permissible whether it's on-label or off-label. The court seems to be headed in a direction that says it doesn't matter whether it's off-label or on-label. What matters is whether it's truthful and non-misleading. And that's one possible outcome. There's a more limited outcome that is also possible, but also would be a big change. Under the prior test for free speech, which was called the Central Hudson test, government could regulate speech if there was a compelling government interest and the regulation was reasonable. The compelling government interest has been identified as getting a company to submit a supplemental application. In the Caronia case, there was a supplemental application and the compelling government interest had already been satisfied. So another potential way for the court to rule is that once a supplemental application has been filed, you can talk off-label about what's in that application prior to approval, again, as long as it's truthful and not misleading. One of the Supreme Court's major points in Sorrell is that we can't have a system under the First Amendment which permits some people to speak about an issue and prohibits other people from speaking about that exact same issue. So that is the case with academic detailing now, where others are perfectly free to go in and talk about off-label uses positively or negatively, and the companies cannot.